Hi, everyone. It's Grant Abbott speaking, and thank you for coming along to this session. And more importantly, it's a draft release of our new binding death benefits direction and nomination. There's a couple of things we've been asked right from the start, and certainly since we've had the system up and running, that can you put in a death benefit nomination? I'm pretty reticent about doing that for a number of reasons. First off is that the typical 100% to go to my spouse is A-OK for the most part if you're trying to do a quick and easy one. The only problem is for our clients, if we set that as a standard, then there's a number of legal issues. First off, if you put that in place and you've recommended that, because essentially if you tell them to do that, you're going down that process of recommending, and you haven't countenanced the fact that the spouse may not be alive at the time of the death of the member that you're advising, or alternatively, that they may have lost their mental capacity, then those sort of issues pop up, and we're really not considering those. So I've sort of sitting back and I've been having a look around, and if you've seen our auto-reversionary pensions, they're quite sophisticated in their import. But again, that's a base level. And for us as advisors, we need to be going to that next level. There's the base level, well, not even a base level. If you ask me, BDBNs or binding death benefit nominations are an absolute disaster. I'm going to talk through a couple of cases there, but there's been at least 20 cases where what's deemed or wanted to be transpired effectively have not been transpired, and they happen all the time. So really, we need to go beyond that. And if you go in and have a look at the law, although the law doesn't necessarily apply to SMSFs as per Donovan and Donovan and also the ATO, most deeds, unfortunately, are written that way. So you're trying to pull in Regulation 619A of the SIS regulations into the deed. And the problem about that, if you go in, and I'm not going to look at this right today, we haven't got the time, we're going to leave that for a full in-depth deep dive into all of this in our October roadshow, early November roadshow. But in essence, the only thing you can put in a binding death benefit nomination is the percentage or dollar amount of benefits is to go to a certain person. So, and you can see that if you go and have a look at Australian Super or CBUS and have a look at their forms. So it's extremely limited in its import. So what we're doing now, and you'll see as we go through, we're moving to a binding death benefits direction and a nomination. So I'm embedding both in together. Primarily, this will apply, using our deed, this will apply to the accumulation side of the fund. Generally, with the pension side, if you've done your auto-reversionaries properly, then that money will just flick on to the next reversionary beneficiary. If there is none and it ceases, which means there's a problem in the way you set that up, then it all folds back to the accumulation and then goes through this death benefits direction and nomination. This, you'll see when we get into it, and I don't want to waffle around too much, but I need you to understand the legalities, the logistics and the practicalities that both myself and also Tony Anamoulis from TGA Legal have built through here to enable you that efficiency, that practicality and that strategy automation so that you're really aware of what you're going through. So we'll go through and in essence, to put it simply, if you look at the legal terms, once this directions is accepted by the trustee of the fund, effectively it means that it's now a contractual agreement not only between current but also future trustees. Now here's where I'm going to get you pumped up, guys. Look, I don't know what it is. I was at the BGL conference the other day in Melbourne, and there were some great people there, but I don't know what's happening with self-managed super funds. People just don't seem to be so much into them anymore, or they seem it's too hard, or they're worried about the T-bar or something. That strategy seems to have been lost, which is crazy because there's currently $750 billion inside SMSFs in Australia. It's the 8th, if you just look at SMSFs alone, it's the 8th largest pension system in the world, for Christ's sake. sorry to blaspheme for Christians out there, but it's the 8th largest pension system in the world. And by the end of this year, it'll have gone above, in fact, it's probably already above the whole of the German pension system, given the fact that their economy is now virtually in a recession. But for the next 10 years, and look, I know someone like you, Tim, you're like very young, and if you have a look at Daniel, like you're super, super young, it's going to virtually almost double in the next 10 years to 1.3 trillion, 1,300 billion. And look, there's probably going to be a recession and markets going to go up and down between now and then, but that doesn't matter because the money will, I always find from experience, and I can show you going right back to the tech wreck. I can show you what happened in 2008, 2009, when the market craps itself, SMSFs take off because suddenly people in Australian super, industry super, or one of the BT supers realise that their assets are going back. They're losing money, even though they're still dumping all their SGC in there. So SMSFs will grow and continue to grow, and next 20 years it's going to grow to 2,300 billion or 2.3 trillion. Now, you tell me, what other industry in Australia is going to see that growth? Certainly not in terms of percentages, certainly not the housing industry. There's no way in the world the housing industry, unless everyone gets out and pops out another child, or we increase immigration to US standards like 1.5 million people per annum, we will not see that growth in any other investment. We're very lucky, of course, after the GFC, that China went on a buying binge and a building binge in order to really propel itself to being the second largest economy in the world. And that meant a lot for our coal and our steel and all that. So we saw growth there. But now, things are very quiet. Now, that's that side. So we've got growth. So look, make sure it's an absolute important feature of your whole, advising armoury. Secondly, you're in on the absolute ground floor. This one webinar, and particularly the October sessions, that I'll be taking you through all the strategies there and the law, because we need to build up our confidence, is that as an advisor, not a lawyer. In fact, lawyers are very, very dangerous, except my mate Tony, in terms of estate planning in this regard. But if you have a look at it, you'll be able to build a very highly sophisticated and strategic estate plan in SMSF. But using our automation, I'm going to show you, you're going to be able to do these in minutes, which now means that you'll be able to build this for clients, and more importantly, send it out in a draft form to the clients, have some thinking around it, have some discussion around it with the clients, come back, send out a letter of advice if you need be, and then finalise all the documentation. So unlike the old days, if you've been to my sessions, for those of you training, remember the old wheel that I used to do? We'd have a look at the trust deed, we'd then look at the Corporations Act, the SIS Act, we'd look at the Tax Act, and then we look at the documentation. That's a lot of wheel to go around, and it means there's a lot for us to know. What I'm proposing and what I'm suggesting is the new breakthrough with strategy automation, and I need your help here a little bit later on. With a strategy automation, we can go straight to the documentation, and then what we can do is we can build it backwards. And when I mean build it backwards, if the documentation is automatically going to fit the trust deed, so that's okay. Tony and I built it from a compliance perspective, so you don't need to worry about the SIS Act, you don't need to worry about the Tax Act. You can just focus in on the documentation and getting to good common sense family protection, family estate planning strategies that are really going to make the best of everything. And you compare that to the BDBNs that are out in the marketplace. Oh my God, they're just an absolute disaster. So for me, the old days of ineffective and dangerous binding death nominations are out the window. And for us, it means we can show the difference in the quality and the calibre of what we can produce versus not only what another accounting firm, another financial planning firm can produce, or more importantly, what a legal firm can produce. And now, certainly with our strategy automation, it now brings it back, and now you become the producer of these strategies, the producer of the documentation, so that what you used to charge lawyers, it's now brought out in-house, and that then goes to your pockets. So from that perspective, when we have a look, there's the big thing that I love and is that over the next 20 years, I've looked at all the demographics, I've looked at all the ATO statistics, I've looked at ages, I've looked at the ABS statistics on life expectancies, and from what we're seeing inside SMSFs, there's going to be $300 billion or more exiting SMSFs as death benefits. Now, I know, probably Tony's already putting his hand up for this one anyway, is that there's going to be a lot of litigation around this. Because for most of our clients, or for many of our clients, apart from their family home, which is usually owned as a joint tenant with the spouse and passes directly over the spouse, most of the wealth is sitting in self-managed. Unless we've got some clear, concise, practical, safe, certain and secure directions that are akin to a contract built under the Superannuation Industry Supervision Act between the member, the deceased member's beneficiaries, you as an advisor, and the trustee, the future trustees of the fund, unless that is put in place, then all disasters are afoot. Anyway, the keys to an effective estate plan. Safety. So it has to be safe, which means it's compliant. So it's not much good doing an estate plan and then finding it can be knocked down. For example, a lot of the industry superannuation funds, if there is no binding death benefit nomination in place for clients there, effectively there can be a great attack on any, the way it works, there can be a great attack on any benefits they pay out. So, for example, if you happen to cross a client, I know I'm talking about SMSFs, but we do come across people, and I know, Tim, we've had a chat with a couple of people. When you do come across these prospects, and they might be clients, or they might be children of clients, or they might be friends of friends who believe they should have been provided more benefits under an estate plan, or benefits that have been awarded by the trustees of Australian Super, the trustees of CBUS. If there's no BDBN, and even if there was, I'd challenge it, you can take a no-cost, absolutely no-cost action under AFCA, not against the dependents or the estate. You can take an action against the trustees personally. Can you believe that? The trustees personally, the directors of all these corporate trustees of Australian Super CBUS, seeking to get an award for an appropriate determination as to whether you deserve any of the beneficiaries' estate. SMSF is not SMSF superannuation estate. So we need safety for us. Safety is, again, it's compliance. Security needs to be something in writing and needs to be certain in writing, and it's got to be of contractual nature. But more importantly, I'm tagging on the next one. And you're going to see, I started with a really broad document, and I want you all to have a look at this document, and I want you to have a look at this video again. You'll probably be able to jump through a lot of this and get straight down to the nitty-gritty. But I want you to be in a position of saying, well, we don't need this, or we want to add this, because LightYear Docs is a sharing community. We're all in it together. We need to put our documents together up on this platform so we can all share, but also make sure that what we've got is the best absolute possible for our clients in delivering the best result. There is no, when you're dealing with family wealth protection, there is no half-hearted measures. So you can see when I go in, I've built a lot of it around lineage, and I'll talk about this a little bit later on. Now, where we go, if you can see in this second point here, by not knowing SMSFs and their strategies and laws, estate planning lawyers are building a world of hurt for their clients. And I've seen this happen, and look, there's a whole range of, even where lawyers have done BDBNs and they've found to be ineffective, lawyers are very, very reticent about doing anything with SMSFs except passing it over to the legal estate. And as soon as our benefits go over to a legal estate, then it's open up for, obviously, challenge under a Dependency Act or Family Provisions Act throughout Australia. And we don't want that. You're going to see when I come through, and I'm going to discuss it when we move on, is that doesn't give me any certainty. Either your clients want safety and they want security to protect their family's wealth, or they just want to throw it away and leave it up to challenge. Now, I can go through a whole range of cases that deal with this, and it's terrible and so sad. But I did come across one earlier this year. In fact, I've come across about 2 or 3 earlier this year. This one was a client who was in a SMSF, and they had their second spouse in the SMSF, had no binding nomination, and effectively they passed away. So his 2 sons from his first marriage were the executors of the estate. They obviously wanted to access some of the $1 million plus sitting in the super fund, as did the spouse. So there was a lot of argy-bargy. He was a corporate trustee. The spouse was the corporate trustee. Effectively, there was no, at that stage, there was no, if you have a look at the deed I've done, both the leading member SMSF deed and the other one, is that the executors would need to be put on as directors, replacement directors of the corporate trustee. Otherwise, the existing trustees are all effectively resigned. So what we need to do is there was no mechanism for that place. So we had a fight between the estate and the trustee, the sole trustee of the SMSF. And of course, because the spouse was the sole trustee, it also meant that it was breaching the self-managed super fund rules if things hadn't transpired within 6 months, which it didn't. So anyway, I told the advisor this, or the accountant this, and there was a problem. What did transpire is, it's crazy that after $150,000 of legal fees, it was decided that 30% of Dad's superannuation benefits were payable to the estate for distribution by the boys as the executors, and 70% was to go to the spouse. Now, the funny thing is, I raised the question, did anyone actually check the constitution of the corporate trustee? Because all the shares were in Dad's name. And if you're using a leading member SMSF, then it needs to be. Because what would happen is the 2 boys would have been shareholders or controlling that shareholding. They could easily have called a general meeting, because if you look at your replaceable rules, the members or the shareholders can actually call a meeting and effectively appoint themselves as directors and take control of that fund, which they didn't do, which was an absolutely crazy position. And my good mate Tony and I sort of sat down and were shocked that $130,000 left that fund because of a couple of bumbling actions from the lawyers. And more importantly, there was not a good advisor there. And I'm going to show you how we're going to protect that and make sure that you guys are in it. So to me, if I have a look at it and say, for me, and I would say for most of you accountants out there, your main claims generally is your SMSF and your family trust, and to also nowadays your companies are the key vehicles for asset protection and estate planning. With the companies, we have to watch out where the shareholding goes. But for the family trust, we can make sure we've got leading member appointors or appointors control that succession planning in the trust. And also that should correlate and corroborate with a leading member or succession planning in the SMSF. But I'll talk about that a lot more in October. I want to get to the document now. So for us, we need to rise above the dull noise in the market and provide real value for service for our clients. Safety, security, certainty, and family wealth protection. What do they not want out of that? Once we master this, then on to estate planning for the leftovers. And when I mean the leftovers, it's for our companies, who gets the shares. If there's joint properties, obviously that goes to the spouse. But what happens if there's a second spouse there? What do we do there? Should we have tenants in common? These are all the issues that we're going to be building over time. So let's go to the binding death benefit directions and nomination. I'll go through really quickly, just this, then we'll go into the document itself. And as I said, this is a sharing community, so I need feedback from you. This is the stuff that I've developed over a number of months with Tony, and it's important that we're putting this in a draft form for you guys to review and come back to us on that. Again, very heavily into family protection. And if your clients don't want family protection, then effectively we need to start to build some exceptions to this document. And we can easily, you'll see when we go through, it's easy to build a lesser version of it, but I'm presuming most of you want to be up the top. First and foremost, we're building necessities, as you're going to see. There's going to be a range of options there for you, and I'm going to cover each one of those importantly. For family wealth protection, we've used the concept of lineage. Now, the problem with bloodline is it's very, very limited. And I was talking about that a while ago, but really I know there's a number of legal firms and they're talking about bloodline and bloodline trusts. It's extremely limited and also very dangerous in that regard, because if there's no bloodline, we should also be able to look at lineage. So, for example, if we're dealing with a gay person or gay client, bloodline means nothing, and that's a problem there. We can deem, if we've got our leading member, SMSF, we can deem their spouse or their spouse to be a part of their bloodline, but that will only apply until they die. So we need the concept of lineage. So that means not only do we go down, but we can actually go up. So we can go up to our parents or our grandparents and make distributions if we see fit along that lineage. So lineage doesn't go down, it goes up. So my idea is it's better to do lineage, and bloodline is just simply dangerous for that. There's also the important leading member SMSF trust, which takes precedence over the estate, will and testamentary trust. So if you've got obviously you can offer pensions to lineage. If they don't take as a pension, they can transfer it to this SMSF trust. So sorry about that. I'll talk about that a little bit. Well, I'll talk about it now. So just imagine now that we've got one of our clients who's died. They're 60, they're just receiving accumulation. They've only got accumulation. So they haven't met that condition of released retirement, which they should have if they're 60. But they've got adult children. They're a widower and they're SMSF. So they've now died in their SMSF and they've left it up to the trustees of the super fund, or the executor automatically appointed as trustees of the fund. From that perspective, what we can do is we can pay we've got three options, and just, in fact, we've only got three options. If they're adult children, we can pay over to the estate. But bearing in mind, once it goes over to the estate, you're now open to the state-based laws and the various family provisions and Dependency Act. Now, if you want safety, certainty, and security, if that's your choice, then we need to show the clients that they're not abrogating the responsibility, that whatever goes over, you can't guarantee it. Even if you've got the best testamentary trust in the will. I'm sure Tony would agree with me on that one. Give me a thumbs up, Tony, if that's the case, that once it goes over the estate, nothing is assured. In fact, it's probably only 20 or 30% assured. The alternative is we can pay a lump sum out to a child, adult child, because they're defined as a dependent under the SIS Act. So under Section 10(1) of the SIS Act, a dependent includes a child. Now, there's a different aspect there, obviously, for tax purposes, but what we can do there is we can pay it out to the child. Everything's okay with that, so there's no drama. But again, we may be facing a problem there with bankruptcy. We may be facing a problem with protection. So what we can do is we can pay it out to the child on the understanding, remember this is a contract, that the trustee of the fund will pay it out to the adult child, provided it is used as a capital contribution to a leading member SMSF trust, which is just effectively a discretionary trust, a family trust, whereby the adult child is effectively the key controller, the key appointor of that family trust. Does everyone get what I've done there? I'm actually paying out, and instead of using a testamentary trust, I'm building a discretionary trust, which is broader in concept and context than a testamentary trust, but I'm building it out of the SMSF. The contract, the nomination I'm building is coming out of that SMSF. Twofold. One is it's not open to challenge from the estate. And why is that? Because it has not gone into the estate. Secondly, it is a trust. So once the capital contribution goes in there, effectively, provided it has been done bona fides in accordance with our documentation, it will not be subject to challenge. And most importantly of all, what it does, it now puts that adult child, puts a veil of protection, which we normally have for our discretionary trust and our family trusts for that SMSF. And there's a nice capital contribution which goes in there, and that capital proceeds can be used or pulled out by the dependent or the adult dependent or their family or any capital beneficiaries at any point in time. Now, like it goes over, if it did go to the estate, there's still going to be 17%. In fact, I think it's only 15% tax on the taxable component. So to me, it's the best way. Now, I want to take you to the next level. If you understand that concept, we're building the trust under. And the good thing about it, by building it under, once it comes out of the fund, it's protected by the Superannuation Industry Supervision Act, which is a Commonwealth law. If in some way, shape or form, some shenanigans went on, then effectively, so for example, if it was transferred to the estate, this trust wasn't created, then effectively whoever, whether it's an advisor, whether it's a lawyer, whether it's the executors, if they partook of these shenanigans, then the adult child who was on the promise, the contractual promise to have a leading member SMSF trust established for them out of the SMSF could take action for any losses, damages, or outgoings, which is, for example, expenses, legal expenses to recover. They can take that as against the lawyers, the accountants, anyone who's been involved in that breach. More importantly, if the lawyers or anyone have actually taken fees in relation to that, an action could be taken under Section 202 of the SIS Act, because there has now been a criminal violation and been a breach of the governing rules. So as a consequence of that, there's a very, very, very big stick to make sure that we lock and load it in. So that's coming out of the accumulation. Now, I've been telling you a lot about doing reversionary pensions down the track. Now, if you've seen my discussion on that, when we do an account-based pension and we do a reversion, it can go from us, like the typical one also can go from myself to my spouse. It can go to our grandchildren if they're financially dependent. And again, we're going to go through all of this documentation when we go through our October roadshow. I need to spend a good 5 or 6 hours getting you guys down and getting a really accredited SMSF estate planners. So what we need to do from that, we need to peel back and say, okay, what happens if the spouse is not alive? And you need to countenance that. If you're using our account-based pension, you need to put that in place. Because just going from, let's say, one spouse to another, that's a complete waste of an account-based pension, particularly if you haven't got good binding death benefit directions. Because on death, if there's no one there to take over, then it flips back. So what we do is, on death, a couple of things. First and foremost is that the auto-reversionary pension continues on in the name of the executor of the estate for a certain period of time. At that point in time, we can leave directions that it goes out to our adult children. Now, at that point in time, we leave it, and you've seen it when I've discussed it, that it is they can take as a pension or a lump sum, which is a commutation, as the superannuation laws allow. Now, at this present point in time, an adult child who's over age 25 and not financially dependent can only take it as a lump sum, which is a commutation. That does not mean that the pension ceases. Let me say that again. That does not mean that the pension ceases and goes back to the accumulation side. What it means is that with your relevant documentation, it can be paid out as a lump sum directly to the adult child dependent and does not have to go to the estate. And again, if we know what we're doing, and after I get this drafted up properly, I'm then going to take the variations, the capacity, the ability to build these leading SMSF trusts out of the SMSF directly. I'm going to take that over to the pension so that the adult child can again partake of the lump sum, provided it goes directly through their leading member SMSF trust, where they are the leading member. And this provides succession not only for the SMSF, but also for all the way around. The other thing that I'm going to show you is that it's all very well to have all of this stuff going on. And again, we're going to look at the documentation now, understand it. We'll go through the process. But at the end of the day, like the case I talked about before that took 18 months, and really at law, that SMSF was not an SMSF anyway. We've got an issue there that effectively our position is that we want to make sure that you are as appointed contractually as the advisor. And if it's not necessarily you, it's your firm. Ideally, it should be you, because you could then assign that if you then transfer to another firm. But firm-wide, you can work out, you make the firm, you'll take control of that estate. And if you've automated everything, then it should be able to be done very, very quickly inside a month. No more than that, rather than festering around for 18 months, 2-3 years, like a cold sore, which I've seen happen in a number of cases. Now, what you have to do is work out your fees in order to do that. So let's just move out of here. I'll come back to the wrap up a little bit later on. And what I'm doing is I'm taking you into what we call, if for those of you who've used our system, you can see this is the actual hub. So this is a draft version of your system. When you go and use LightYear Docs, there's a framework for you to jump in and utilize the system. For those of you who are licensees, so you've got a 1, 3, or 5 year license, you can go on straight away, and there's no limitation on the amount of documents you can do. You can build one, save, you can go on ad infinitum. The alternative is that I'm building it straight out of the hub, because this is in a draft form. It's for your review. So I built this one earlier, so we'll just go through and I'll cover. So the first one is, what's the name of the fund? So it's no brainer there. The date of the application. So the first step is, it's a twofold process. The member applies for a binding death benefit direction nomination. That is not automatically approved, obviously, by the trustee, because they need to read it, and once they sign off and execute it and send that back to the member, effectively it becomes more enforceable, more powerful than any contract anywhere in Australia or around the world, because it is now enforceable under the Superannuation Industry Supervision Act. And as I said before, if there's any breach of this binding death benefit directions in any way, manner, shape or form, anyone who suffered loss, including, listen to this, including yourselves in terms of fees, fee loss, can recover against the trustee or any person, the lawyer, the accountant, even the auditor, who's been party to that loss. And more importantly, if they've benefited from it, whether by way of fees or simply taking monies that were not attributable to them, then effectively there is a potential jail sentence under Section 202. So this is where we're playing. We're getting, this is the safety and certainty. So that's why we want to get there. So we put in the members' details, John Giles Smith, so on and so forth. So a lot of this stuff is perfect. We will be integrating with class, so you'll actually be able to do this straight off class. BGL, we're going through an integration process there for them now, so you'll be able to pick up the details from BGL when we come around to the trustee. So we've got a corporate trustee here, which obviously is my recommendation at all times. We've got a company, Smith Nominees, got the ACN, the street address. We've then got the directors. When you go through here, you need the sole director 2+. If you do 2+, you need to simply put in the number there, click that confirm, and then we'll pop the relevant boxes. So put the 2 directors' name, and they're both going to be signing. So that's pretty stock standard, really. And actually, just to go back on that, we can use our integrations with class and BGL and all that, but honestly, it's, for me, by the time you go through the integration process, it's just as easy to almost do it straight off. Okay, so now we're getting to the guts. 5 questions, and I want you to, I'm going to explain each one. We're then going to have a look at the impact on the document. So the first one is, does the member want to revoke earlier nominations? So you've probably never ever seen this in a document before, certainly not a BDBN or any binding directions, and I've never put it in. But we need to do twofold. One is we need to revoke any binding death benefit nomination or directions we've had before. We don't want to have that capacity for someone to challenge it. Secondly, you'll see when I go into the document, we're not only seeking to revoke, and I can't guarantee it for you, but we're not only seeking to revoke stuff inside the, don't like that legal term, stuff inside our superannuation, but we're also seeking to extend it into the will, such that any notification around superannuation in the will effectively is to be overridden by this and is hereby to be revoked. So I'm having a chat with Tony and I around this, and we will be doing a letter of advice for you if you're seeking to look at that. So that's a revocation. It's easy if it's an early BDBN or what I call a BDBD. Next one is, does the member want to appoint the executor as a replacement trustee or replacement director? Well, I would have thought that is an absolute given. Again, it is going to be subject to the trustee. However, if we've put this in and the trustee accepts it, this now becomes part of the trustee. Does everyone understand what I'm getting at? Why I'm getting so secure and safe? By the trustee signing this off, even if there is no mechanism built within the deed or the corporate trustee to make an automatic appointment, by doing this, so that's across the board, doing this, the trustees have to do that. If they fail to do that, again, we're open to losses and outgoings under section 55(3) and also criminal prosecution under section 202. As an aside, because there's a breach of any of the Commonwealth laws, we can also be caught, I think it's under section 43 of the Commonwealth Crimes Act, as aiding and abetting a breach. So you've got to be extremely careful around that. So does the member want death benefit payments? Well, I think that's pretty obvious. By clicking yes there, you can see this opens up. Like if I had no there, that closes that box. By doing yes, can you see on the left-hand side? That no opens the death benefit payments, which is really the main guts of why we're here. Look at this. Does the member know? I take that out, see, on the left-hand side? Yes. That now puts in a contractual term, again, stronger than any contract around the world, was now bound by Commonwealth law, that you as a professional are to be included for the distribution, the carrying out of all responsibilities as per this binding death benefit direction for the estate, and an agreed fee which binds not only the current trustee but the future trustee. Now let me ask you, what happens in place? We set down a fee and then the client or the trustee refuses to pay that fee. Remember, you're in there to make it quick, get everything over and done with quickly, efficient, certain, safe, secure at a set fee. Now, if they don't pay you the set fee, where are you going to go? Well, first off, you come to TGA Legal, let us know, and pretty quickly we'll take an action under Section 55(3), with also the forewarning that there's potential criminal action under Section 202. Can you see why we want to have this in place? It also means we're not going to have those 18 months, 2 years, or 6 months waiting for the distribution. We want this quick and fast. And you don't need to necessarily worry about probate on this. We can sort out the SMSF estate because it sits outside probate. Now, do you want a catch-all escape clause in case the super benefits are not payable because non-compliance of the fund? So what happens, for example, remember I talked about those lawyers who took 18 months and it cost $130,000? Effectively, that fund was non-complying. So do you want to put an escape clause in there that if everything that's being done actually breaches the SIS Act, or something that has happened to breach the SIS Act, do you want to have an escape clause? And I would strongly recommend that you have yes, and I'll show you anyway. Oh gosh, I'm running out of time, but anyway. So we want to put the death benefit. So we're going to our spouse, which is okay. Now I've got a flexible option. Now the flexible option means that the spouse can get a percentage on death. Doesn't need to have 100%, it can be less, and the rest will then go down to children of the lineage of the deceased member. So anyone who's a child can receive the remaining percentage. So we could do 100, and I'll just put here 25, oh, sorry, 20%. So if I do 75 there, let me just talk it through. That means that the children, only the lineage children, and that's defined, you'll see when we get through, are to receive proportionately, equally, the remaining 25%. Now I could do 100% and then effectively, if I do it 100%, it's probably best to go the income stream option. So if it's an income stream option, then it means it automatically goes to the spouse 100%. And then what we can do is we can put some capital preservation in there. So if I go back, I can have a flexible option or the income stream option. So here I've gone 75, so it means my lineage children can effectively get 25%, and I'll come back to that. Now, for a child under 25, the pension they will receive effectively is, because they have to, if they're an adult child, sorry, if they're a child under 25, then it obviously has to be commuted by age 25. Now, what I've done is I've made the pension non-commutable, so they can't actually access a lump sum. And in here, you can put the maximum percentage of drawdown as pension income throughout that period. So, for example, if I passed away and I've got my 17-year-old daughter, Tiana, she's to receive an income stream. So I might have, for example, 50% going to Amanda, my spouse, and then my other daughters are to receive the remaining 50%. But because they're both under 25, it's non-commutable, and then I can work out, well, how much can they take of that each and every year? And it could be 10%, it could be 15%. Obviously, you're going to have to take the minimum pension amount, but for them, it's obviously going to be 4%. So you need to be above 4, but if you put 100% there, effectively they can take all the pension as they want. Now, here's a new one that I haven't really seen anywhere else. Remember, we're getting beyond, all of this stuff is getting beyond what's available under typical binding death benefit nomination, which puts you in a great stead. Here, you can now make a specific bequest, provided the trustee has those benefits, and it makes it a lot easier if your existing or the deceased existing superannuation benefits are in a sub-fund. For example, if you've got residential property sitting in a sub-fund, or for example, a farm in a sub-fund or gold in a sub-fund, it's easier to treat it akin to a will where we've got a specific bequest. So here, yes, we've got a specific bequest for Jim Smith's, who's the son of John Smith, and there's the family farm. So effectively, all of this stuff is great, But what will happen is Jim is to get the family farm first. Does everyone follow that one? Specific then overrides this. We could, for example, go our income stream option. So, for example, if Janet was the spouse from the second marriage, but Jim is the son who's from the first marriage and is working on the farm, if we did this, Jim gets this, then Janet gets everything else. Does everyone understand the smartness, the automation that's coming through here? And of course, the other child be getting gold in the fund. So if there's specific bequests, I'd probably go down the income stream option here, but I just want to show you the flexible option as well. So that's it. So you can see there, I've done it pretty quick. And what I'll do now is, oh, sorry, I forgot about you. That's terrible, isn't it? The most important. So we've got John Jones, who's our accounting professional or advising professional. So we then have to work out what the remuneration payable professional. Now, if this ended up where a lot, believe it or not, a lot of SMSFs will end up in the public trustee, believe it or not, because of problems with the trustee, then they'd be charging 8%. So let's say you charge 2% of the assets sitting in the fund for the benefit of John Smith, and that is payable to you. You might just want to do payable within 7 days after the distribution of the last amount of John's SMSF estate. How's that? And see, really, if you go back and have a look at the distribution to Jim Jr. or whatever, effectively that means that it's easy to transfer the property out, very easy. So we just do a transfer, and I'm automating that process as well. We then go to the next, we have our meeting, we've got all the relevant people there, and then let's go and have a look at the document itself. So I'm just generating. Again, I'll send this out to you as a draft document if you'd like for that. In fact, just contact us on 1300, or more importantly, just contact us at support@lightyeardocs.com.au if you would like to have this draft document. I'd like to keep it very within you guys only, because the last thing I want is to see this being transferred out, or this knowledge going out to some of our competitors, because it is very revolutionary, as I'm sure you're finding out as we see fit. So what I've got here is I've got the document itself. So binding death benefit nomination, directions and product disclosure. So as I said, you've gone through this process. You can do this multiple times. If you're obviously in that position, if you obviously just getting a document by document basis from us, you can always go back and change within 30 days. But if you're, you obviously take it a lot longer if you are on our licensee or unlimited. So what we need to know there is we just simply put it out as a PDF, send it off to the client, put a draft stamp on it, they can have a look at it. Now, because it's dealing with a benefit, we've got a product disclosure statement. And really, you can see here, the payment of death benefits from a superannuation fund is determined in accordance with the governing rules of the super fund, not in accordance with the terms of the deceased will, which is essentially where we're going. Now, we've got a whole lot of information there for the client to read. Suggest that they read it very carefully. We've got who can get the death benefits. We've got a whole lot on who's a financial dependent, how that's determined, why lump sum may not be suitable for some beneficiaries, the taxation of the estate. We've got their binding nominations and directions, which we're talking about. What is it, etc. And then we move on to remember the application. So the first one is request to accept the following. So remember the first one, revocation of earlier death benefit nominations. The member by this document, upon acceptance by the trustee of the fund, hereby revokes all prior legal and non-legal binding death benefit nominations, directions, SMSF wills, or any other document, and I've put that in to cover wills, seeking to distribute the member's superannuation benefits in the event of their death. Again, whether that is enforced, I'd love to see an executor try to challenge that. If you have a look at all the cases, Katz and Grosman, Donovan, the super fund always has precedence over the will, as the commissioner did at that point in time. So I'd love to see that challenge. Appointment of a replacement trustee. The executors of my legal estate will be appointed as my replacement trustee and stand in my shoes as member of the fund until the final amount of my super death benefits are paid. If there is no executor, there is to be no replacement trustee. If there is a company trustee in my fund, my executors will be appointed as a director in relation to distribution of my super benefits upon my death. Now, if the current directors refuse that, then effectively we can take an action under 55(3). So you're going to start to see now lineage as defined as the direct descendant of the deceased member only, but may include any other person if deemed to be a lineage beneficiary. So I'm going to probably just need to change that. So rather than direct descendant, it's descended up and down the track, as you'll see a little bit later. So the spouse flexible option. If my spouse, Janet Smith, remains alive at the time of my death, my spouse is to take 75% of my super benefits in any manner or form that they desire. The remaining 25% is to go proportionally to my direct lineage children that remain alive at the time of my death. They may take these death benefits as a pension or as a lump sum, as the superannuation laws allow. Now, again, I can put in there, if we need be, I might bump that up and maybe make an election there that it might end up in one of these leading member SMSF trusts if you choose to do so. But again, I'd love your feedback on that one. 2, if my spouse is not alive at the time of my death, my superannuation benefits are to go proportionally to each of my lineage children to remain alive at the time of my death. Any child that's under age 25 is to be paid a non-commutable pension. Remember, I said this, to age 25, with any drawdown in any income year to be limited to no more than 20% of the pension account balance. Any child over age 25 must take the payment as a lump sum or pay it into a leading member SMSF trust at the instructions of any leading member of the fund at that time. So it can be forced into a trust, and I might make an election in there. Do you want it forced, or do you want to take it as a lump sum? So I think that's pretty important. Next one is, if neither my spouse nor my lineage children remain alive at the time of my death, my superannuation benefits are to pass to my estate for the primary benefit of my lineage, despite anything contrary to in my will. So again, if it goes over the estate, it has to go to lineage. If there is no lineage, then to the lineage of my parents, including brothers and sisters, nieces and nephews. Again, I'm using section 55(3)(202) to force the executor to make sure it only goes to the lineage, despite what happens inside the will. In the event of my death, and I have specific assets backing into my super benefits, these will be transferred to the following beneficiaries. So again, you've seen that takes precedence over the others. Nomination of a professional to review my super estate. John Jones from Jones Accountant, which is effectively you, is to be appointed as a professional to ensure this death benefit directions nominated are properly attended to in a reasonable time. John's to be paid an amount equal to 2% payable within 7 days after the distribution of the last amount of John's estate. Actually, I should be putting there of my superannuation benefits. So I put in that full stop. It should be last amount of my superannuation estate of my super benefits unless agreed with the trustees of the fund. So don't put a full stop after that direction. If John is not retired or no longer alive, then such other person the firm he last worked for provides. So I need to just tighten up that one. Again, I've only just finished that. So if John is retired or no longer alive, then such other person the firm he last worked at provides. Superannuation benefits not payable. Remember, we ticked that. If the above benefits are not payable due to the superannuation laws, my super benefits are to be distributed in a fair manner by the trustee of the fund directly to my lineage as at the time of my death in such manner of form as the trustee wishes. So we've got the member, we've got the 2 witnesses there, and then we've got all our binding trustee resolution, which now makes it contractual. So we've got the trustee resolution put in place, sought professional advice, blah, blah, blah. Trustees to forward this trustee to the member as notification of the revocation of all earlier death benefit nominations and directions and the commencement of the binding death benefit nomination direction as noted in the member's application. So again, that goes down and it's signed and effectively we're off and running. So that's where I'm at this stage. As you can see, through going through our fairly easy, if we have a look through our interview, simply by going through this process, we're just relaunching it here. By going through this process here, and I think the first couple of pages are pretty easy, that when we start going in here, This is where the guts of everything can be done. And we need to know this, in quite a lot of detail. Now, these are all options. Now, within each of these options, when we go yes, for example, death benefit, I can then start to add a whole lot more options and flexibility. But I wanted to get down the basics for you to understand that this is the new world that we're effectively moving into. And for me, it's just so super exciting, and there's a lot of options. So what I will do is I'll put this video up on for you to have a look at it again. And again, if you'd like to have feedback, if you'd like to have a look at this document, please feel free to contact us at support@lightyeardocs.com.au or call me. I'm available on 0418 735 491. So that's 0418 735 491. Or importantly, just go to our normal number, 1300 168 380. And I'd love to have your feedback, and just come back to me or email me at grant@ilovesmsf.com, which isn't a highly used email. And we can start to say, have you thought of this? Have you built this? Because at the end of the day, from our perspective, as I've got up here, we're a sharing community. We want this to build so we can then go to our clients and provide a really safe, certain, and secure scenario. And more importantly, go out and help our referral sources for that, so that we're now seen as above being the better than the best. We will be launching the full estate planning suite. So this is just for the accumulation side or the pension side. We'll be building the auto reversion, we'll be building this. We've got that SMSF leading member trust. Remember, the one that floats up out of our superannuation estate. We'll then be building our estate. So for all those non-trust, non-SMSF assets, you'll be able to build wills and also testamentary trusts, which will be similar in vein to what I've just discussed. What will happen though is, for anything that pops out of the SMSF or the family trust, you've got full authority to do. But once you start moving out to the estate, effectively what we've got there, essentially what we'll do is we'll provide you legal sign-off through obviously TGA Legal. I've got a really good Ken Race, and sorry Ken, I've been really meaning to call you, and I will do so today, I promise. Ken, you're right. You said, great session, Grant. I think I will need to see this at least one more time to get it right. In fact, we're going to need to see it a lot more time to get that confidence. It's like that leading member. So with the automation, you can see it works really well. We will be doing a roadshow around Australia, and what we're going to be doing is that will start after school holidays, and I'll be spending a good 6 hours with you going through the law, going through everything else. Eric, thank you for putting your hand up. I am coming to Sydney to have a chat with you about that really big estate plan for you and starting to build in some disability trusts. Don't worry, I'm going to work really closely with you on this. So watch for the dates, and I'd like you to bring along, because it's not going to be expensive because you guys are using us anyway, bring along your staff and your referral sources. So we all become a learning organisation, and your referral sources can actually start to see what you can and cannot do. Again, this is new stuff, but the revolution about it is it's strategy automation. We start with the documents first, knowing the compliance is built in, and then we can then pass it to the client, explain it to the client what it means in perspective. If they then want to change, then we can come back to our document and make the requisite change. Anyway, for me, there's $300 billion coming out in the next 20 years, and all of us should be super excited about that. So let's go out and let's learn more. Love your feedback. I'll send this out. Make sure if you need the thing, get in touch with me. And there's a few people there that I will contact. Ken, I'll also be contacting Tim. I'll be showing this again at the Change GPS Summit on the 2nd of September in Brisbane. So hopefully I'll see some of you there. Anyway, it's Grant Abbott signing off.